So I'll start here by just saying that basically there are several types of these directives. Substitute decision makers, and that's like an agent under a power of attorney. They cover proxy decision makers in here, which, hey, that's a new one on me. I've never been involved in that before. Okay, but I'll explain a little bit about that. Guardians, who are appointed by the court, you probably all are familiar with those because some of the people you take care of you have to deal with their guardian. And then they talk about living wills in here, a CPR directive. You're probably more familiar with those than I am. I don't have anything to do with those. I'm a lawyer, so I don't deal with CPR directives. My mom had one, you know, and it was important to everybody that she have one. And then there's what they call medical orders for scope of treatment. Never dealt with those either. So I'm gonna talk about, I'll talk about all of this, some of it really briefly because I know very little about it. But I'll spend some time on the medical durable power of attorney and the living will. And I'll go through those forms that are at the back of this with you. I wish you had the forms in front of you, but anyway. Oh, good.
I started one a while back.
Okay. All right. So I'm going to talk about the forms, but before we do that, I'm just going to give you an overview of some of these concepts so you are familiar with what I'm talking about. Advanced directives are they are in advance of you needing to give instructions to your healthcare provider. We're assuming you're competent. You have to be competent mentally at the time you make these healthcare directives. That's one of the basic concepts that you need to deal with yourselves, of course, if you're going to make one, but also when you're dealing with people who say, oh, I've got, you know, or I don't have one of these advanced directives, and they say, but I'd like to make one, or I'd like to change mine, you know. I don't know whether you're trained in, when you're dealing with your folks, the people you're taking care of. I don't know whether you're trained as to determining their competency or not. But it's kind of a, you know, it can be either technical or it can be common sense. And so you know, but you understand the concept that somebody has to be competent in order to make one of these things. So that's the first thing that comes to mind if you're dealing with somebody else. Are they competent to make this thing? They want to make one. I've got the form, or they have the form. Are they competent to do this? Do they know what they are doing? Or if they're trying to change it, they say, I don't want to do that anymore. I don't want this directive anymore. I want to change my instructions. Are they competent to do that? So that's a primary concept to get in your mind. Okay, so if you're competent, yes.
On this advanced directive, a copy has to be at their positions, right? Or not?
Well, we'll get into that.
Okay.
I want to cover some of this stuff first, and I'll get back to that. They explain in this document that you have certain rights if you are a person and you have to be competent to exercise these rights. You have a right to receive information and understand risks about medical alternatives, give consent to medical treatment, refuse medical treatment, and then make these advanced directives like a power of attorney or a living will. All of those require competency. It doesn't do much good for the doctor to be interviewing you or the nurse to be interviewing you, and you don't understand what they're talking about. That's why a person would need an agent in the room with them that they've appointed to sort of help either interpret what's going on and understand and explain to the principal. The principal is the person who made the power of attorney, or make that decision themselves. Listen to what the doctors have to say and make that decision themselves. So we have these advanced directives. I'm not going to talk about informed consent too much. It's a concept you need to understand because, of course, if you're competent, you can make your own decisions. Even if you've appointed an agent under a power of attorney, the agent doesn't get to make decisions for you until you're not able to make those decisions yourself. If you're competent, if you're in bed and even if you are receiving health care treatment at that time, if you're able to talk to and understand what the doctors are saying and communicate with them, you don't need an agent. I mean, you may feel like you want somebody there to help you, but they don't get to make the decision. You make the decision because you're competent. You've got all your marbles. You know what you're doing. You know what they're saying, and you can make a decision. So that's the concept of informed consent, competency, informed consent. But if you are not competent any longer, that's when you need the agent to step in and help you. And if you are unable to communicate at all with the healthcare providers, and it's an issue that's covered by the living will, that's when your living will would take effect. So let's see here. We'll get into okay, so we've covered those competency. You're still able to understand and consent to treatment, and then no longer able to. Medical durable power of attorney covers that situation. You want to have a healthcare agent who has authority to make those decisions for you, and that is usually somebody who's close to you and knows what kind of wishes, knows what you want done. Sometimes that's a relative, sometimes it's not. Sometimes you have to, when you're thinking about appointing an agent, you have to consider whether that person that you're appointing is going to be an appropriate person to exercise, let's put it this way, to carry out your directives, what your wishes are. Not for them to make an independent decision about what they want done with you, but to carry out your wishes about what you want done. So, and sometimes your relatives aren't the best people to make that, to be appointed to that, because they're so emotionally involved in you that they find it difficult to separate themselves from, to be analytical about the situation and say, well, what would mom want in this situation? What would dad want in this situation? I've talked to them about it, hopefully. I've talked to them about it. They've expressed their wishes on this. I don't care what my brothers and sisters are saying. I've got the power. They've appointed me to do it. I've talked to mom and dad. This is what they want done, and that's what's going to get done. Those are the kind of people that you should appoint as your agent. You don't want necessarily your best buddy to be doing that, because it's going to be, it's a difficult decision sometimes. Some of these decisions are difficult, and you want that person to be able to make that decision so that it fulfills your wishes. Let's see here. All right, those are the basic concepts for a medical durable power of attorney. The article that you've been given describes other kinds of decision makers. There's a proxy decision maker for healthcare. Sounds like sort of a impromptu committee that gets together. This says the doctors call together a group of people who then decide who is going to make decisions, and it's on a short-term basis. It's not meant to be permanent. It's a short-term basis for a particular purpose. It's really, they even point out in the article that this is an unusual situation. But it's worth reading about it, but I don't think it happens very often, mainly because medical powers of attorney are pretty common now. Medical powers of attorney are. Most people have them, I think. This just isn't necessary very often. But you can read about it. It's a group of people that's called together. And of course, that depends on who the doctor knows to call. Hopefully the person who is receiving treatment is able to still communicate with the doctor about that. I want these people called together, you know. These are the people I want you to talk to. And then they get together. They decide who's going to make this decision, okay? That's called proxy decision maker. I haven't dealt with it. That's not that's not what I do. So I don't know that much about it, and I think it's a relatively new concept. Then there are guardians. You probably, like we kind of discussed, you've probably dealt with guardians off and on. They're appointed for people who are unable to make informed decisions on their own. Either they have a mental incapacity or a physical incapacity. This article points out that they may manage the financial affairs of the person. That's actually a conservator. It's a different kind of appointment by the court, and the law separates those. The guardian takes care of the person, the body, and decisions about the body, placement, medical treatment, that kind of thing. Conservator takes care of the estate of the person, meaning their assets, their income, pays their bills, and pays the guardian sometimes. And this is why the two aren't usually linked together, because the guardian may be paid to do their job, and the conservator is the one who is paying them. So you don't want those two things linked necessarily. Okay, and then they deal in the article with medical orders for scope of treatment, which again, I don't know anything about. I wouldn't necessarily, because this is something that the doctors or the hospitals generate. And it's supposed to be a consensus type of document that the patient, the person being treated, is asked to prepare with their doctor's help, and then it's used and it follows the person around so that their treatment is sort of uniform throughout their care. And we know how that goes. You're probably familiar with that too. You go to one doctor, and then they don't have, and then you go to another one. They don't have the records of the previous doctor, and then you go to the hospital, and they don't have the records. Or it's not as common here, because I think people are very good about sharing that kind of information in Grand Junction, but other places maybe not so much. Okay. The medical durable power of attorney. It's on page 9. The discussion starts on page 9 of the handout. It's naming someone to make healthcare decisions when you're not able to. And they're called an agent. Now, and I'll go through this on the form with you, but it bears repeating here. The medical durable power of attorney can take effect immediately when you sign it, or you can sort of reserve that and say, well, it's only going to take effect when I become incompetent. But actually, like we discussed before, it only takes effect when you're incompetent anyway, because you are going to be, the doctors and the nurses are going to talk to you about your health care. For as long as you are competent to make decisions, they're going to talk to you and they're going to take instructions from you. That's your right to make informed decisions about your own health care. So really, this distinction isn't much of a distinction between effective immediately and effective only when you're found to be incompetent. Okay, one of the concepts you have to think about is, this points out the person has to be willing to serve as your agent. Now, sometimes I've had people come into the office and we're going through the forms for the power of attorney, and I say, well, okay, who do you want to serve as your agent? Because I need to get this information so I can draft up the documents. Oh, I want my son. Well, have you talked to your son? No, I haven't talked to my son about it. Or I haven't talked to my daughter about it, or something like that. The person and the reason is they have to be willing to do what you're asking them to do, and you need to be able to explain to them, I want you to carry out my wishes. I want you to do what I want to do, and this is what I want you to do. You have to communicate with that person about what you want to happen to you.
Secondaries as well.
Pardon me?
Can you have secondaries?
Oh, yes. Oh, yeah. And I think that's highly recommended, because the question was, do you have successor, they're called successor agents, okay? What happens if the person you choose, first of all, can't or won't serve? They just go, this is too tough for me, I can't do it anymore. I don't want to do it anymore. You need backups, successors named in your document. People who you've talked to, again, who are willing to take on that burden. It really is a burden. It's a responsibility. It's a big deal. So, yes, you do need to try to find one or maybe even two people to help you out in that situation. They point out in here, and I've had this come up, they point out in here that co-agents are not recommended. I draft wills for people, I draft powers of attorney for people, and a lot of times they don't want to leave out one of their children. They have a couple of kids, and they just want to make brother and sister both agents, and I go, don't do that. Don't. Please, do not do that. Or they want, do you know what a personal representative is? It's like an executor, okay? They want both of them to serve as personal representative. And I tell them, please don't do that. The law will make sure that the other kid is included in all the information that is necessary to administer your estate, but you need to have one person in charge. Co-agents just become very cumbersome. And as you can imagine, in a healthcare directive situation, you could have conflicts between those agents. They get in a fight over what to do and whose decision should prevail. That's not a good idea. That doesn't help the doctors at all. It doesn't help the hospital either. Now they've not only got an incompetent person that they're trying to take care of, but they've got people who are fighting over what to do. That doesn't help anybody, and it doesn't help the patient either. So you want to appoint somebody who's willing to do this and who is knowledgeable enough about your wishes to carry out your wishes under your power of attorney.
I have a question on.
Yes,
power
ma'am.
of attorney. Say for instance, if your daughter or your son becomes your power of attorney, and you decide that that's what you want, but yet I have a question about assets. So once you sign a power of attorney, the person that signs power of attorney would be responsible for that person, any liabilities or assets that they have, you know?
No,
No?
not under a medical power of attorney. That's a
Okay, so it's
different kind of power. There are two powers of, usually two powers of attorney
What's the other?
that I prepare for people. One of them is called a durable general power of attorney, all right? And under that one, you may be giving your agent, you don't have to, you can pick and choose among the powers you wish to give them, but you may give your agent power to do everything you could do with your property. Everything you could do with your property, including file your tax returns, deal with insurance, deal with the banks, buy and sell property, pay your bills, pay your other liabilities, all those kinds of things.
The person would have a lot of bills. The person that signs the power of attorney, would they be responsible for?
No,
Okay.
they're an agent,
Okay.
and the agent is not, in fact, you want to make that clear if you're serving under a power of attorney for someone else. You can say, look, I'm their agent. I don't pay the bills. I'm simply making health decisions for them. Because some people, they always want to get paid, understandably, and they'll mark down that you're the responsible person on the sheet. Have you ever seen that? You go to the hospital and they say, who's the responsible person? Not the agent. You mark agent. I'm not responsible for, if responsibility means I'm going to pay the bill, no, that's wrong. I'm not going to pay the bill. Okay? The general durable power of attorney is part of the kit, if you will, for estate planning that lawyers usually put together for people. But because just like with medical decisions, people can lose the ability to make financial decisions too. Or they're just incapacitated. They're stuck in a bed and they can't get up and deal with the banks and paying their bills and all that kind of stuff.
So it allows them access but not responsibility.
Yeah. You mean the agent?
Like to handle the banks.
Right. Though they have a fiduciary duty under we're talking about a financial power of attorney as well as a medical power of attorney here. The agents have a fiduciary duty. So, and okay, that word means whatever they do, they have to exercise they have to exercise their powers for the benefit of the person who appointed them. They don't just get to do whatever they want to do.
Right.
They have to do it for the benefit of the person that appointed them. They're like a trustee. I think everybody more familiar with that term. A trustee is also a fiduciary, but a trustee holds property, but it's in trust for other people's benefit. It's not for their benefit. They don't get to just spend the money. Some people are afraid, and it happens, that they'll appoint an agent and the agent will, take all the money out of the bank and go off to wherever and have fun. Well, that's not what they're supposed to do, and that's why you got to be careful about who you appoint as your agent. Well, let's get back onto the power of attorney, the medical power of attorney. You can cancel it, you can revoke it at any time, but again, this is an issue about competency. You can't cancel something. Let's assume you've made a medical durable power of attorney, and now you're sick, And, you know, so the question is, are you competent to revoke it if you think you've changed your mind? That's a question that has to be answered. That's one of the primary questions that need to be answered. All right, living wills. Living wills are like the ultimate advance directive, I guess, because everybody understands they pretty much deal with end-of-life decisions. And as it explains in this article, they're for the purpose of telling the doctors to stop life-sustaining procedures if they've already started them, or to never begin them. Okay, never begin those life-sustaining procedures, and there are prerequisites to this. The living will doesn't even start to take effect unless you're in a terminal condition and can't make your own decisions. Okay, those two, you have a terminal illness or condition and you can't make decisions, or you're in a persistent vegetative state. And that is, you know, everybody understands what that is. That's like Terry Schiavo, who was brain damaged as a result, I believe, of an accident or something. And then, you know, they were feeding her through a tube and keeping her body alive, but her brain, the doctors had determined, was pretty much either dead and it was actually reducing, you know, in size and quality. So that has to happen before the living will even takes effect. First of all, if you're still able to make your own decisions, you can tell the doctors what you want. You don't need the advance. Putting it in writing's not going to be any more powerful than you actually talking to the doctors and telling them what you want to happen. Okay? Again, it's a terminal condition and you're not communicating, you're unable to communicate with the doctors, can't make your own decisions, or you're in a persistent vegetative state, meaning, of course, you can't discuss anything with your doctors because your brain's not working. So the article explains a little bit more, probably better than I can, about what those conditions are. But so read them. It's a good article on it. A living will is an advance directive. You put it in writing. It's witnessed by two independent witnesses. As the article explains, is not two people who know you or who are going to inherit something from you or are related to you. It's two independent witnesses. We always use people in our office to witness these kinds of documents. They usually don't even know the people the client who we're drafting the document for. It goes into effect 48 hours after two doctors certify that you either have the terminal condition and can't make your own decisions, or you're in this persistent vegetative state. And at that time, then they notify people, your family and others who you may have designated, that, okay, now it's time to think about this living will and what we're going to do with the decision that's made in the living will. When we go through the form, you'll see that you can designate who you want them to talk to, right? You can put that right in the living will. In Colorado, you can designate in your living will that your doctor should stop or not start any tube feeding and other forms of artificial nutrition and hydration. Once you've reached that terminal condition and you're unable to communicate with your doctors, or you're in this persistent vegetative state. And that doesn't mean that they can't give you something to relieve pain. They will always do that. But it does mean that they may remove, or will remove, if you've directed them to do that, the feeding tube, so that your body isn't kept alive. And some people just stop eating anyway. But remember, you're in a condition where either you're being fed artificially, or and they've already started that procedure, or you don't want them to start that procedure. All right. Again, you can cancel a living will, revoke a living will anytime, but you've still got this issue about competency. You got to determine competency first if somebody is going to revoke a living will. This article talks about CPR directives. Again, I don't deal with those. I don't fill them out. They have a form of one at the end of this packet. Everybody understands, I think, what CPR directives are. They're a directive not to begin artificial resuscitation, I think is what they call it, even if they think it's needed. So this is a decision that every person would make about whether they want to be, revived, I suppose is what you'd call it, if the situation arises. Like I said, my mom had one. It was bright green, I remember. Posted on her, it was posted on her refrigerator so that if the ambulance was called, they'd see it, and they wouldn't try to revive her. I don't have one. Maybe I should, but I don't have one. I've never talked to the doctor about that. Anyway, they're available. I'm sure your doctor could help you fill it out and explain it probably better than I could about, what the effect of that is. All right, let's look at these forms. They start at the end of the article, after page, what is it? After page 15, after the credits on 16, okay? So the first one we'll talk about is the medical durable power of attorney. So at the very top, it asks who the declarant is, and that's you, or whoever's making the power of attorney. Then they ask you the name of the agent, the phone number, email, home address. They want to know how to get in touch with the agent. Remember, the process for this is you make this power of attorney, and then you're going to give it to your doctor, and the doctor, probably in Grand Junction, will scan it into a system, and then they share that electronic data with other healthcare providers in their network, I guess, is what they do. I have never been through that, but I think that's what happens. Or, somebody is going to have the piece of paper in front of them, and you're in need of help from your agent, and they're going to get in touch with the agent. Or the agent is standing right by your bedside, and they want to verify that that is really the person who you've named in your power of attorney. So they're going to check their driver's license or other identification against what you've got in the power of attorney. And this power of attorney gives broad powers to your agent, says to consent to or refuse or stop any health care, treatment, service, or diagnostic procedure. Has authority to talk to my health care professionals and sign forms and all that kind of stuff. So then it has its spaces below that. They're talking about alternate agents. This is a question about appointing somebody to take the place of the agent who may have died in the meantime. Before these powers of attorney they're often made well in advance, and 20 years later, somebody comes up with the healthcare power of attorney and say, well, who's this guy? Oh, he's dead. Well, that's not much help. Who is the alternate? Well, that's so-and-so, and he lives over here, and he's still alive. He's 10 years older than he was when he was appointed, but he'll agree to do it. That's why you need these alternates in here. People who agreed to serve as your agent may, at some point, become enfeebled themselves. They don't, it's good to appoint somebody usually who's a little younger, hopefully, than you are. So they're able to serve when the time comes. Or they may not want to do it anymore. They don't feel up to it for some reason. They may be sick themselves. There could be all kinds of reasons. So you need to think about alternatives.
Can you appoint a child who's not yet
No, because you have to have somebody who's over the age of 18 at least be appointed.
You can also have a friend, it doesn't have to be a relative.
Right,
Like
it can be anybody.
kids first and then-
Yeah, it can be
But on
anybody.
this primary agent signature,
Mhm.
is that where my name would go and then my other two alternatives, like if I picked a friend and a dog?
Are you looking at, oh, you're looking on the next page.
I'm looking on the durable power of attorney
The medical durable power of attorney, right.
here.
Signature of the appointed agent. Yeah, I'm not there yet, but I'll
Oh,
get there.
I'm sorry.
I'll get there. I'm not, yeah. Okay, okay. All right, this next part, this Roman numeral 2 part, okay? Roman numeral 2 part. Yeah,
Oh,
right here.
Uh-huh.
Okay? This is what I was talking about earlier about when does it become effective. Well, I usually counsel my clients to just make it effective immediately. You don't know when you're going to need to have an agent anyway. You could walk out of the office, get hit by a car, and now you need somebody to act as your agent. Now, you have to be determined not to be able to, your competency is always a question, but you may need help navigating the medical system when you're in that condition, and your agent should be able to help you do that. So you want somebody who's going to be serving without question. Nobody needs to make a determination that you are unable to make or express your own decisions. But that just leads to delay. I mean, doctors aren't immediately available anyway. And this calls for when my physician or other qualified medical professional has made that determination. Why not just make it immediate? This person you are appointing is somebody you trust anyway, hopefully. I mean, they're not going to be making decisions that are counter to your interests. I mean, I hope they're not. You've determined that they are the proper person, and they have agreed to serve as your agent. So this person you trust you should just go ahead and make them immediately able to exercise those powers if need be. Sometimes people are wary, this language, sometimes they're wary, is my agent going to take control of me when I still have the ability to make decisions and control my own destiny and all that kind of stuff? They're worried. Older people are often worried about that. Again, I just counsel them, look, appoint somebody that you trust. to act for your benefit, and then you don't have to worry about whether you're competent and some healthcare professional has determined that you're unable to make your own decisions. Let's go to number 3 here, instructions to the agent. This is pretty important stuff here, and I'm going to suggest a couple of things. It says, my agent shall make healthcare decisions as I direct below. You've given them general powers in here. So really, under this power of attorney, they could make all kinds of decisions. But there may be some that you want them specifically to take note of. For instance, if you've made a living will, you want them to abide by your living will. Usually, I mean, that's why you did it in the first place. So, in this part, you might say, I've made a living will and I want my agent to follow the directives in my living will. As simple as that. You may want to put that in here so they don't, there's no conflict. Somebody reads your living will and then your agent comes in, oh no, that's not really, I don't think that's what they wanted. If it's what you wanted, you made the living will, tell the agent that you want them to make decisions according to your living will. You've already made that directive. If you've made a CPR directive, like we talked about, the do not resuscitate order or the, I can't remember the name of that thing, but anyway, the CPR directive, tell them, I have made a CPR directive and I want the agent to follow the directions in that directive. You may want to give them instructions about your wishes with regard to hospice care. Okay? You may want to give them directions about, specific directions about placement in a nursing home. Don't feel bad. I want my agent not to feel bad about putting me in a nursing home if that becomes necessary. Because some people just don't want to go there. You know, they go, oh, geez, I'm putting grandma in the nursing home. You know, that's terrible. She's just going to go in there and die. Well, if she needs to go to the nursing home, relieve them of the burden of guilt. You might put something like that in there. Those are suggestions.
Question before you move on. If you want to do like a medical power of attorney for a minor, say parents are going out of state or country, would you use something very similar to that, this form, or is it completely?
Well, there is. I have not seen people use powers of attorney that way.
Okay.
I think you probably could do it. What they do is they appoint a temporary guardian, and you can do that in a written document where if you're leaving the country and you want somebody to be responsible for your children and they want something that says they are responsible for your children because they may need that.
I have a child that has medical issues, and so if I'm planning some vacations, I just want to make sure while I'm gone, if something happens,
Yeah.
my mom can make decisions while I come back.
Yeah, under Colorado law, there's a statute that provides that you can appoint a temporary guardian, and it,
that would cover the medical.
yeah,
Okay.
yeah, because a guardian can make decisions about somebody's health care.
Okay. Yeah.
All right, let's go to the next page of this medical durable power of attorney. The signature of the appointed agent. You had a question about that. I don't think it's not necessary. It's kind of optional that you get the signature of the appointed agent. This form is kind of nice because it points out to your agent that they understand that they're always to act in accordance with your wishes, not their own. So it kind of emphasizes that to them. It gives them some instruction about being an agent, and that's a good thing. So, yeah, if you have the opportunity, I don't think it's absolutely necessary for you to do that in order for the power of attorney to be effective. A power of attorney is your appointment of somebody else, their consent to do it. That consent doesn't have to be necessarily in writing. But this is a good thing. It's a handy thing, especially if your agent's a little vague about what they're supposed to do, or you want to emphasize it. And then it has on it the signatures of the witnesses. And as I was saying, these are independent people. These are people that don't have any relationship to you, and they're, they're willing to sit down, and you should express to them at the time that they're signing that this is your power of attorney and you are appointing so-and-so, and you want them to serve as witnesses to that fact. Okay? They talk about the notary as being optional in this. I strongly recommend that the document be notarized. If I'm somebody who's who is handed a power of attorney and I'm expected to honor it, I don't necessarily know the people who are involved, and a notary, what they do, a notary, you're familiar with them. They will look at the person. They assure. It's kind of an assurance that the person who signed the document is the person appearing in front of them to sign the document. And so it's some assurance to a third party out there that this document is authentic. It's the real deal. So I think the notary should, I highly recommend it. I think it should be required. And it is on a lot of documents in Colorado because they're actually recorded in the clerk and recorder's office, and they have to be anything that has to do with real estate. This doesn't deal with real estate or anything like that. I'm not suggesting that, but I think the notary is a real good idea.
I am, Nikki is, Marlis is, Mary
Okay.
is.
Got plenty of notaries to choose from. Good. All right. All right, let's go on to the living will. The living will, is in parentheses. It's an advance directive. This is the next document in the packet. And again, you're making a declaration. I'm at least 18 years old and able to make and communicate my own decisions. I'm competent and all that kind of stuff. It's my direction. Remember, this is the prerequisite to any effect of this living will, is that 2 qualified doctors think I have a terminal condition and I'm unable to communicate, or a persistent vegetative state. So those are the prerequisites to any of this being effective, and it's stated right up front in this document. And then it explains what the terminal condition is, all right? Or it explains that condition. If at any time my physician and one other qualified physician certify in writing that I have a terminal condition, kind of walks through each of these different prerequisites. If you do have a terminal condition and you're unable to communicate with your doctors, then you have a couple of different options here. One option is I direct that all life-sustaining procedures be withdrawn or withheld, not including comfort and pain. Relief, not including treatment to relieve pain. Or I direct that life-sustaining procedures shall be continued for a certain amount of time or until a certain point, and you can think about that. Most people who come into my office, they are thinking about the situation that we've talked about, where you're brain dead, or you're in a persistent vegetative state, you're being fed with a tube, or you've got a terminal condition, you're gonna die, it's just a matter of time, and there's nothing they can do for you, and they're feeding you, or they're giving you something, some kind of life-sustaining procedures, They want that removed immediately. Remember, the doctors have to make a determination first. That's going to take some time. They're not going to do it immediately, unless it's just immediately obvious that you're in that state. And even then, it's 48 hours before the living will can even become effective after they've made that determination. So you could be laying around in the hospital for quite a while. And most people, when they think about that, they think, well, I don't want it to keep going on. I just want it removed. Other people may have different view of that. And so they would say, well, I want to continue it for 5 days or 10 days or 15 days or 30 days or something like that. That's up to them. But I would say most people that come into my office say, just withdraw the life-sustaining procedures. Then they talk about nutrition and hydration by tube. If I'm receiving nutrition and hydration by tube, I direct that one of the following actions be taken. And one of them is to just not continue it anymore. The other one, that it be continued for a while or until there's a certain goal reached. Or that artificial nutrition and hydration shall be continued. They give them that option, I think, in this form to make sure that they understand what they're doing. Then Part B talks about the persistent vegetative state, and basically the same options are available there. Other directions, it says, please indicate below, I'm on Roman numeral 2 here, please indicate below if you have attached to this form any other instructions for your care after you are certified in a terminal condition. For instance, to be enrolled in a hospice program, remain at home, discontinue or refuse other treatments such as dialysis, transfusions, etc. I haven't had anybody make those kinds of directives so far in filling out one of these forms in my office. But I think it's a good idea if you have ideas about that. I mean, if you've thought about it, you've thought it through, I think that's a good idea if you're going to tell people that you should tell people about this. Again, Roman numeral 3 deals with that issue about, well, what about my medical power of attorney? And how do these things work together? If you've made a medical power of attorney, you want your agent to follow your living will, probably. I would say that's probable. So you should tell them that, both in here and in the power of attorney. Okay, on Roman numeral 4, this is where they ask you for the names of persons they may consult with. I authorize my healthcare providers to discuss my condition and care with the following persons, understanding that these persons are not empowered to make any decisions regarding my care. This would be other people. This would include your agent. It might. But it's particularly other members of your family or friends or some people you're close to who might be visiting you and so forth, and they want to know what's going on. Then Roman numeral 5 is actual notification of other persons. These are the people that need to be notified once you've reached that state where your terminal condition or a persistent vegetative state. This is where the healthcare providers notify them after this 48-hour period, after they've made that determination, and okay, now, all right, what are we going to do under the living will? 6 talks about anatomical gifts, and most people don't, they kind of shrug and go, yeah, I guess so. Yeah, why not? That's been my experience. Give them whatever they want. Old people go, well, they're not going to want any of me anyway. So, and I say, well, don't be so sure. They may want parts. You never can tell. It's kind of interesting in this article. They talk about how your living will, your advance directive, may not take effect immediately, even after the 48-hour period, because the hospital, if you've made an organ donation, the hospital may want to keep you alive. You guys know about all this stuff. The only reason I know about it is because I talked to Dan Prinster about it one time, who was involved in one of these issues. And I hadn't even thought about that. I hadn't even thought about that. But it's a good idea that you be aware of that, because that's going to delay the directive in your living will that feeding and hydration be withdrawn. And again, they have witnesses, and this absolutely has to be signed in front of witnesses. And they talk about the notary being optional. I say you need a notary. You need to sign it in front of a notary, and the witnesses need to sign it in front of a notary to make it official. The last document is the CPR directive, which again I don't know much about, and you can look it over and understand why I don't know much about it, because it's a pretty, I mean, it all deals with things that are medical, and I'm not medically inclined. I'm a lawyer, so I don't know that much about this stuff. All right, well that is the overview. So do you have questions about what we covered?